A judge in Mississippi said he had no choice but to declare a mistrial in the case of two white men who are on trial for shooting at a black FedEx worker. Those two white men, Brandon Case and Gregory Charles Case, are charged with attempted first-degree murder, conspiracy, and shooting into the vehicle of DeMonterio Gibson while he was making deliveries. The judge made the decision because the detective in the case admitted to errors. Brookhaven Police Department Detective Vincent Fernando admitted under oath while the jury was out of the courtroom that he did not give prosecutors or defense attorneys a videotaped statement the police had taken from Gibson. This is what the judge said.
You know, during Detective Fernando's testimony, and it's been the subject of motions, he's a very important witness in this case. The court ruled in limine preliminarily that the shell casings found, I believe, in the home were not admissible, and furthermore that, and everybody agreed on this, both parties, that Mr. Bates, in fact, the defense gave Mr. Bates the ability to essentially ask a leading question, and that is, did you find any handguns in the house? They agreed not to object. The question was asked, and once again, Detective Fernando blurted out, no, but we did find long guns, which was also excluded in limine in a preliminary hearing. And then we get to his testimony, and wherein there's a disc of the victim, Mr. Gibson, writing a statement, and I haven't watched it. I don't know what was on it, and candidly, that really doesn't matter. We don't get to say, oh, well, the rule got violated, but it wasn't that big a deal. That's a decision. It's got to be turned over. In pretrial discovery, it was not turned over. I have no idea whether there were other things that weren't turned over. And I can assure you, no one hates a mistrial more than the court, because once again, we are in the position of coming back here doing the same thing, and we've essentially spent 3 days that end up being wasted time and effort. But under the circumstances, and I'll quote the totality of the circumstances, between in limine matters that were testified to, I had to twice admonish the jury to ignore, or once, Mr. Kitchens didn't want me to do it once.
Out. Now, folks, the judge, and he was not happy at all with the detective. He had some strong words for him.
Since I started practicing law in 1993, the policy of the 14th Circuit Court District Attorney's Office has always been an open file policy, which works great, except for the fact that the state of Mississippi can only turn over evidentiary items to defense counsel if they are provided with those items. I don't know when this case was indicted. I don't have it in front of me. I can't remember it. It really doesn't matter. The bottom line is this file should have been turned over to the DA's office prior to the indictment. And by file, I mean the entire file, including a video recorded statement of the victim, which was also requested by defense to the DA's office. Mr. Bates acknowledges that. He acknowledges that he was told that it didn't exist. And lo and behold, here we are on the second day of trial, and we find out something that these attorneys have been looking for at least a week and potentially months is actually in your file. Mr. Fernando, you understand, you've got to turn your entire file over to Mr. Bates' office for him to be able to prosecute these cases. Do you understand that?
Yes, sir.
So you come out with a video of a statement that nobody's ever seen before.
Now, it's about a 4.5-minute video there. The judge was not happy. Carlos Moore joins us now from Martha's Vineyard. He is the attorney for Mr. Gibson there. Carlos, I saw a report where the mother of your client just stormed out of the courtroom. She was not happy at all with this mistrial.
That's true. Rightfully so. She is very much disturbed by today's developments. Her son has waited long enough for justice. This happened in January of 2022. The indictment was not to November of 2022, and here we are in August of 2023, 2.5 days of trial, and then the judge declares a mistrial. And so it is very disturbing to not only her, but her son and to everyone involved.
This is not hard. if you're a cop, you turn over everything that you have to both sides.
Correct. So we believe this was very deliberate and intentional on the part of the Brookhaven Police Department. From the very beginning, we have said that they have played favorites with the cases. We do know that the assistant police chief at the time of this incident was Chris Case, who I've been told is related to Gregory Case and Brandon Case. And so they have done everything they can to delay, and to try to help the cases beat this case.
So for folks who don't know what this means, walk folks through it, because this is just now more delays. So what are we talking about here? A month, 3 months, 6 months, a year?
We don't know. The best case scenario from speaking with the prosecutor is that this could be retried in October of this year. That's the judge's next term of court. However, he already has cases on that on his docket for October, and he may not be able to fit this trial in October. Adding insult to injury, compounding things, is the fact that the prosecutor retires in December. So if he retires in December and a new prosecutor comes in January and has to come up to speed, who knows when this case will go back to trial.
Just absolutely gross police misconduct. Just makes absolutely no sense whatsoever. Have you talked to your client? How's he doing?
My client is trying to keep the faith. He is discouraged. He is despondent in a way, but he's still undergoing counseling and has been undergoing counseling since this incident occurred back in 2022. But he is not going to give up. He does know that justice delayed does not equate to justice denied each time. And he believes that at the end of the day, once a fair and impartial jury is seated, that he will get justice. And he's willing to fight for however long he has to fight until that day comes.
And of course, new trial means have to go through new jury selection, all of those different things. Carlos Moore, we appreciate it, man. Thanks a lot.
No problem. Thank you.